Good afternoon and a very warm welcome to the Next Your Employment webinar in the series, providing you with essential employment law and HR updates. For those of you that are new to our webinars, we are of course Jones Chase, a firm of specialist employment lawyers, and we act for a number of companies from PLCs all the way through to startups and also for some fantastic individuals too. And we have a very high success rate of looking after those that we represent, and we are delighted to have you with us today. And so just briefly, we've got an awful lot of content to cover, and plenty of people from the firm are here to speak today. So we've got two of the firm's partners. We've got Shona and Susanna, one of the firm's senior associates, Harriet, and also a trainee solicitor, Dom. And they're going to be covering an awful lot of forthcoming changes in employment law. And in terms of format for the webinar, if you want to ask us questions, please use the Q&A box. If you want to do that anonymously, please hit the anonymous button if you want to do that. If you don't mind your name being displayed, you can use the chat box as well, which we'll be also monitoring. And what really helps us to keep the conversation flowing is if you want to say something to us, please use the drop-down menu and select the all panelists and attendees, which is quite useful because then everybody can see what you're saying and it just makes it easier for everyone to follow the flow of the conversation. If you want to speak live, and in 3 years of doing this, only one person's ever done that, please mention that in the Q&A box and either myself or one of the team can unmute you. I should add that we are recording the webinar to reach those that couldn't make it at 4 o'clock today. And I'm sure you all know, but just to emphasize that the points that we are covering are not formal legal advice. And so much depends on the facts of the case. And sometimes the approach that you take in one case is not the approach that you take in another. Therefore, please do not rely upon this webinar for legal advice and do get in touch with us instead. The context and facts of any particular case are very important. Another quick reminder that the information that we're covering today is accurate as of 4 o'clock on the 22nd of June 2023. Things are changing very quickly, as they always do in the world of UK employment law. So do drop us a line if you have any questions. And lastly, we do like helping people. And if you find our content useful and you believe that somebody else may also do so, please feel free to share our contact details with them. You can reach us at info@joneschase.com and we can sign that person up to our webinars and mailing list as well. Okay, so very quickly moving on from me, there's plenty of forthcoming changes in UK employment law coming up. And I'm going to pass on to Shona, who's going to speak about the proposals to limit non-compete clauses and also a review of the whistleblowing framework. Shona has to leave the webinar at 4:30 today, so unusually we can have, if you have any questions about her section, please ask them and Shona will answer them before she departs the webinar. Okay, so that's enough from me and over to you, Shona.
Hello, thank you, Dean. So the first topic is non-compete. Just as a reminder what a non-compete is, it's a post-termination restriction. So when an employee leaves, it's to impose an obligation on that employee not to compete with your business and therefore to protect your business in that period of non-compete time. They're usually relevant for very senior employees, but can be highly relevant to technical employees, those that are researchers, people with know-how within your business that have information, particularly information in your business that you want to protect once they leave, and or maybe salespeople who have that great client connection that you want to protect that connection on the employee leaving. So the non-compete is a clause that says the individual will not go and join a competitor in a role that they've done, which is same or similar to the role that they did with you. And it's for a particular period of time. And that clause is enforceable if it is reasonable. And reasonableness is shown mostly to do with the duration of the clause itself, but can also be the scope of the information you're trying to protect, or even the clients that you're trying to protect. This is all a matter of common law, and common law is what case law that is decided by the courts, and it's the judge that decides what's reasonable and what isn't reasonable. But that the government have now decided they would like to limit non-competes to a period of 3 months maximum. So previously there was no maximum, but the courts would determine if your clause was reasonable. Now the government is suggesting change to legislation, the introduction, in fact, of new legislation to say it should be for 3 months. There's no time frame for when this legislation will come in. It's a proposal. And the government are basing their proposal on the fact that they want to protect the UK economy can see why, the state we're in at present, but they want to protect the UK economy by allowing flexibility within the workplace and not fettering people's rights to do whatever it is they want to do when they leave your employment. And so that 3-month period is seen as the minimum period in order to help that economic growth. This throws up a number of problems. One is you may have non-competes already in your employment contracts, which are longer than 3 months. What happens to those? Do they automatically get reduced to a 3-month period, and or will you have to enter into new contracts which provides for that 3-month period? That may be something that's taken care of in the legislation. It also provides an incentive for you to think now about your other restrictions in your agreements. That is the protection of confidential information, the protection of client context. Those are non-dealing and non-solicitation clauses. Protection of suppliers. Does this person have any right to contact our suppliers for a period of time once they leave? And or the protection of poaching your key employees. Those particular restrictions are not being considered by the government as having a limited time frame. It is only the non-compete. So you may decide we'll put more emphasis on those other restrictions: non-solicitation of customers, as I said, non-dealing of customers, not taking your suppliers, not poaching your employees, and confidential information. The only problem with that is it's very difficult to police, particularly the confidential information point. It is very difficult to police the use and or disclosure of confidential information when employees go to a new employer. And that's why the non-compete usually comes into its own. So you may decide, okay, there's limited amount that I can do with the clauses in my contract, but I may think of the way I operate my business. So I will only share what I know is really confidential information with those on a need-to-know basis, and make sure that those individuals are bound by a very strict confidentiality clause. So you're limiting the risk. At the moment, I sometimes find employers are quite free with information that they share with maybe more than they need to. And so you consider who you're sharing with, and also you consider what is confidential, so that you're very clear and it's marked confidential on the document itself. So that's the non-compete. The government are thinking about imposing a 3-month time limit. There is no time frame for when that will be introduced, but now I think is a good time for looking at your restrictions post-termination to see that they're fit for purpose if that 3 months comes in. The next topic is whistleblowing. Whistleblowing was introduced into our law in Great Britain in 1998. It's had a couple of reviews since 1998, mostly around whether things are done in good faith or not, or where the good faith element or test appears. But the government has asked for some research on the impact of the whistleblowing legislation. And the main reason for this is because 1 in 4 employees who blow the whistle are dismissed. And that's information that's come from Protect, the charity that monitors whistleblowing statistics. Equally, there are a twofold increase, or 100% increase rather than twofold, 100% increase in whistleblowing claims from 2014 through to 2021, which is the latest figures that they have for those claims. So there's a significant number of whistleblowing claims in the tribunals. And the fact that 1 in 4 people are dismissed if they blow the whistle. This research has been triggered in order to see the impact of it and whether the protection that's afforded by the whistleblowing legislation is in fact good enough protection. So the whole purpose of the whistleblowing legislation in the first place was to provide a route for somebody to blow the whistle, to provide protection for that person who does blow the whistle, and then to have this sort of cultural change to feel that actually that can be done, a whistle can be blown, and that will impact the way employer does things, or improve how an employer can do things. And the research is to see, has any of that actually happened? Has the impact of whistleblowing actually allowed for employees to make disclosures safely to their employer without then suffering either a detriment and or dismissal? And this is something it's saying that it also wants to understand how whistleblowing information is provided to employees, how they know what they can do, where they can do it, who they blow the whistle to. And it also wants to know the impact on employers, how do they respond to whistleblowing, and what is their reaction if the whistle is blowing. One of the things that it's not doing, it's not gathering evidence on reporting channels and protections where there is no workplace relationship. So it's only in the workplace that they're looking at the whistleblowing framework that we have in place at the moment. This is research that's going to take place between now and the autumn, and then there will be a report on it in the autumn. What happens to that research in the autumn, it's not clear, but there will be a report on it and we'll all get to see what the impact is. I have to say, from my perspective in dealing with whistleblowing cases, that the main problem appears to be knowing that the whistle has been blown. If it's been done through a confidential whistleblowing line, then it's very clear. You know that that whistle has been blown on that topic. You may know who it is. Usually those lines are anonymous, but you may know. It's where an employee believes that they've blown the whistle. They haven't said as much to the employer. Something has happened to them, maybe dismissal or detriment. And as a result of that, they then say, oh, by the way, I blew the whistle. That's why you've now dismissed me. And the employer did not know that the whistle had been blown in the first place. So I think one of the main changes I would like to see is some clear structure as to how the whistle is blown so that everybody knows, the employer knows, the employee then knows their protection is effective from that date. And that, I think, would provide for a more effective protection. I don't know if anybody else has got a thought on that, but maybe not, maybe.
Yeah, no, I totally agree, because a lot of the cases I think that certainly as employment lawyers we get involved in now on the claimant side, and other experts in HR and employment lawyers would be looking to try to find something that could be a potential protected disclosure. So you're totally right, it's not often very overt that the whistle has been blown. It's often picked up retrospectively, which isn't what the law really should be supporting, I suppose. And of course, whenever we're drafting whistleblowing policies, one of the key things that we would do for our clients is to make it quite clear. Well, you try to make it very clear that if an employee is blowing the whistle, it's done pursuant to the policy, so you're aware of it, and then you've got a policy framework within which to act accordingly.
Yes, because you can't insist that they use that channel. So, and you're right. You're therefore you're trying your best to channel it in that way, and it's and I'm not sure, but the insistence point with that has to come communication on how you do it. Otherwise, I don't want to limit individuals' rights to blow the whistle. It's just that it's then known that that's what's happened.
And
sorry, Suzanne, I think you're going to say something.
No, I was just agreeing. I was agreeing that is the problem, is that I think both employer and employee sometimes there's a disconnect as to whether or not the whistle has been blown.
Yeah,
so,
yeah, that's right.
Clarity would be good.
Yeah, exactly. And irrespective of the changes in the law, having a good whistleblowing procedure in place will help the employer, because it should then be alert, and then employers can react accordingly. Because one of the problems with whistleblowing is a failure to act upon the whistle being blown. If the employer is not aware of it, and obviously any detriment or dismissal, which could happen almost accidentally or as a side point, but if somebody has blown the whistle, then this needs to be treated very carefully.
I'm just going to cross-sell here. Susanna and I did a podcast. Susanna found a cracker of a case where a risk officer reported on the risks within the company. That was his job, and then decided that that was blowing the whistle and used that as a whistleblowing allegation. That's in a podcast that we did. So I'll just finish now with having cross-sold the podcast.
And just to finish on that, the podcast called Case Notes, they can be found on our website in news and events, joneschase.com. Also, from memory, Spotify as well, and Apple Podcast and Buzzsprout. Forgive me if I got the name of that wrong, I'm not very tech savvy. But I'm a big Spotify fan with music, and yes, they're on Spotify and our website. And
we don't sing.
Okay, that's good. Well,
it is good to know.
No, I was sorry, as in I shouldn't be singing. So absolutely the worst singing voice on planet Earth. And surely you have to leave shortly, I know that, but just going back to your points about the changes to the consultation on non-competes, just whatever the team think, would this have an impact upon the length of garden leave, for example? Does anybody have any particular views on that? What's everyone's thinking? I mean, if the non-competes get shorter, one way employers can protect themselves with very senior people is obviously to have a longer notice period with garden leave to lock that person out of the market of joining a competitor. But of course, one of the issues with that is it's more expensive because you have to pay notice period, and if someone's very senior, that'd be very expensive. So there could be some contract variations. It could encourage longer notice periods being used for senior people. If anybody has any thoughts on that, feel free to. But that was just something that just occurred to me.
Yeah, it's interesting. I'm actually seeing a bit of an upturn in terms of for very senior employees, where actually the notice periods are being extended for a very long period of time. So the periods are usually around about 6 months, whereas I'm actually seeing that employers are putting in 12 months now. And I don't know if that's in anticipation, where they're thinking about this as being an issue, but the fact that they could then potentially also reserve the right to put them on garden leave for that whole 12 months, although expensive, they've obviously decided that actually in the round it's a really effective way of managing a real risk. So from my perspective, I've actually had discussions with clients about this and whether or not that's what they want to do. So yeah, I think it's certainly making people think.
Yeah, so that longer notice period, I suppose, because of the work pool, the number of people out there in jobs and working is reducing. That's probably encouraging keeping people there for longer. It's a great level of security for the employer. I wonder about the argument about atrophy of skills. You're sitting there for 12 months on garden leave, and you just say this is unreasonable.
But if you've invited the employee to take legal advice on their contract of employment before they've signed it, and that's a subject that they've been advised on, I don't think they're going to get very far with that argument.
I agree. And then I wonder if I'm a highly reputable individual, I'm sitting on 12 months notice, I'm really sought after, I get a new all singing, all dancing job, I'll just say, bye, you can keep your notice, I don't want garden leave, I don't want your 12 months notice, I'm leaving. And then if there's a 3-month non-compete, that's much better than being stuck with 12 months and the new employer will want to pay you for that 3 months. That's another way out of it.
Yeah, that's true. But also you could apply for an injunction to enforce the garden leave provision. And you could also go for damages if, for example, so I think
with a lot of these,
there are ways of tying people up should you need.
Yeah. I think the cost of injunctions has got to the stage, though, where with a small employer in particular, and those are the ones that want to hold people in as long as they can, they have to decide, well, do I want to spend this on seeking an injunction? I agree, Susanna, there's remedies for things, but do they have the stomach and the purse for those remedies?
And just before we move on to Harry's section, just very briefly, it's if anyone attending the webinar isn't aware, it is much easier to generally enforce garden leave than it is a post-termination restriction, which because the person's getting paid and is subject, it's in the contract, whereas a restriction, there's more ways in which it could be deemed to be unenforceable. So it can be a safer way of protecting your business, albeit more costly because you have the salary impact as well. Shona, that's great. Thanks for that. I know you do have to leave, so thanks so much for speaking today. We'll let you go. And
I'll hang on for a wee bit and hear. Yeah. I'll hang on for a wee bit. Yeah.
Okay, fantastic. Just moving on to Harriet's section, and Harry's going to speak to you about the new employment protections for parents and carers. Over to you, Harriet.
Lovely, thank you very much, Dean. So I'm for some reason my notes seem to have disappeared. Okay, here we go. So I'm looking at, there's 3 sort of key changes in this area when we're looking at sort of parents and carers that are going to be coming into force over the sort of potential next year or so. I'll come on to when we think they might come into force. And these concern pregnancy and family leave and redundancy, neonatal care, and leave for carers. And all three bills concerning these protections received royal assent on the 24th of May. And so these bills have now become acts of parliament. But all of these acts are sort of enabling acts, which empower the Secretary of State to make further regulations in due course. So we've got these acts which can bring these things into force, but only through further regulations. And we don't yet have the regulations. So I can talk in general terms about what we think these regulations are going to say, but in terms of the actual detail of it, we'll have to wait until a little bit of time into the future for those. So looking first at redundancy, so we now have the Protection from Redundancy, Pregnancy and Family Leave Act 2023. And this is going to enable regulations to be brought about with increased protection from redundancy during or after pregnancy or after periods of maternity, adoption or shared parental leave. So currently, the law is that under Regulation 10 of the Maternity and Parental Leave Regulations 1999, before a woman on maternity leave is made redundant, an employer has to offer her suitable alternative vacancy where there is one available within that employer or an associated employer, which I expect most of you will be aware of. And if an employer doesn't do this, this may result in the employee's redundancy being automatically unfair, so an automatic unfair dismissal claim. And it also could give rise to a discrimination claim on the grounds of pregnancy and or maternity leave under the Equality Act. Now, this protection under Regulation 10 is limited to the duration of the maternity leave itself. So it doesn't offer any protection once the employee has returned to work. And sometimes we see that employers may wait until the employee has returned to work before putting redundancies in place, because they then don't have to offer a suitable alternative vacancy as a more automatic right. So I think generally there are still a lot of issues with employees returning from maternity leave or the family leave and then being made redundant. So I think that's the idea behind this protection. So we're going to get protection after the period of maternity leave as well as during it. And we understand that this period is going to run from the date that an employee notifies the employer of her pregnancy. So it will also run before the maternity leave. And we think it's almost certainly going to be 6 months after the return from maternity leave. So it's really extending this period of protection under Regulation 10. And it's going to be extended to similar types of family leave, such as adoption and shared parental leave. Although in terms of the period of protection for shared parental leave, that may be a bit different because you can take shared parental leave. Some people take it for a much shorter period. So it may be that the period of protection is going to be proportionate to the amount of time off that the employee takes. So we'll have to wait and see about the detail there. And I think as with these other changes, we don't know when it's going to come into force, but I think we're unlikely to see any changes before at least April 2024. So it's not imminent. And just thinking through the implications for employers, in relation to these changes, I guess employers can start thinking through the fact that new and expectant mothers are going to be able to effectively double their period of protection to about a period of 2 years. If, for example, they told their employer about their pregnancy at 12 weeks, they take a year of maternity leave, and then they're protected for 6 months afterwards. And when I say protection, I mean, women can still be, or people taking this leave can still be made redundant, obviously. This is just the special protection where if there is a suitable alternative vacancy, they have to be offered it in preference to another employee. But it could cause issues if you're running a redundancy exercise and potentially you have a particularly female-dominated workforce, because you're going to have a much larger number of employees potentially who may be given priority for suitable alternative vacancies. So because you've got a longer protection, you have employees who are pregnant who have come back from maternity leave, as well as those on maternity leave, who are then going to have this additional protection. So it would be just a question of thinking through how that's going to be managed in terms of how those vacancies will be offered to people. And it's likely that the regulations will state that a failure to offer a protected employee a suitable alternative vacancy in these additional periods will also mean that the employee has a claim for automatic unfair dismissal. So this is going to be quite a big change, and employers really need to get their head around this additional protection. Moving on now to neonatal care. So currently, parents of a baby who is in neonatal care in hospital, they have to rely on their existing statutory leave entitlements to take time off work whilst their baby is in hospital, which is not ideal. So based on the consultation, we've got this Neonatal Care Leave and Pay Act 2023, and this is going to put through future regulations to allow those who are eligible, whose newborn baby is admitted to neonatal care, to take up to 12 weeks of paid leave. And that's in addition to other leave entitlements such as maternity and paternity leave. So if a woman comes back from maternity leave or would have finished their maternity leave, their baby then has to go into neonatal care, they can have up to 12 weeks following the maternity leave or whenever it occurs. And the length of leave and statutory neonatal pay will be based on how long the baby receives neonatal care for, and it will apply if the baby receives this care for more than 7 continuous days before they reach 28 days old. And it's going to be available to employees from the first day of employment, the leave is, and the statutory pay will be available to those who've got 26 weeks continuous service and earn more than the lower earnings limited. And from my research, it stated that these new entitlements are expected to be delivered in April 2025, so a bit longer away than the other changes potentially. And I understand that these new rights may affect around 60,000 parents every year, so it's certainly something that's hopefully going to help a lot of people, which is great. Lastly, turning to carers, which I think is also something that's very much in need. An estimated 2 million people in the UK are balancing their work alongside unpaid caring responsibilities. And obviously with the ageing population, this is only probably set to increase. And doing this, I think, must be incredibly demanding for all of these people. And I've also read that around 600 people per day leave the workforce because they can't maintain this balance. So we're losing an awful lot of people just because they cannot balance their work and their caring responsibilities. And again, there's currently no dedicated statutory leave entitlement for people in this situation. So if you're an informal carer, so if you're also in employment, you just have to rely on other types of leave to meet these responsibilities. So, for example, parental leave, if you're caring for a child, or just use their annual leave. Now, employees have got the right to unpaid time off to handle emergencies and certain other situations involving dependents, if it's children, spouse, parents, but you can't take this type of leave where you know about the situation beforehand, which obviously limits how it's going to be used. So, for example, if you needed to, or an employee needed to take an elderly parent to a planned or routine hospital appointment, you can't use this emergency family leave. So we're finding that employees are increasingly using the right to request flexible working to try and help accommodate these caring responsibilities. But again, this is obviously dependent on the flexible working pattern being workable for the employer as well. So the Carers Leave Act 2023 will, through, again, future regulations, allow these unpaid carers who are also in employment to take up to 5 days of unpaid carers leave per year. And this is to provide or arrange care for a dependent with a long-term care need. And all this detail is going to be set out in the regulations. But a long-term care need means that they must have a long-term illness or injury, which could be physical or mental, and that requires or is likely to require care for 3 months or more, or is a disability as defined in the Equality Act, or they require care related to old age. So it's going to be sort of set down as to what the sort of care situation is. And this is going to be available to employees only and is available from the first day of employment. And it could be taken in a block of 5 days or in individual or half days to suit what the individual needs. And again, we don't know when it's going to come into effect, but we probably won't have the regulations in force before April 2024 again, so hopefully sometime next year. And obviously this is only 5 days unpaid leave, and if somebody has got a lot of caring responsibilities, this isn't actually a lot of time off for them. So this is only a minimum that employers have to provide, and employers obviously might want to go further and offer more than 1 week's unpaid leave. And this might be something that you want to think about in the workplace if you find that your employees are affected by this. And employers could think about formally recognising working carers, actually talking about it, developing policies and practices with the aim of becoming a carer-friendly employer, and potentially providing all carers with the right to take longer periods of paid leave as opposed to the unpaid leave. So it's something that you might want to start having a think about as to whether, you know, this may affect people in your workplace and actually you want to do something that's a little bit more generous. And obviously, as always, if you're thinking that you might want to develop policies around these rights, do let us know and we would be happy to help. And that's all from me.
And I just wanted to raise something in relation to that I recently just used, and it sort of worked to a certain extent in increasing a payment to an individual. So the new rule coming in about extending protection for women returning for the 6 months, you know, and the redundancy situation, it's a useful thing to be able to use for extending an argument for a longer period of compensation. Because one of the things that we always argue when we're representing individuals is that, you know, a mum coming back from maternity leave is going to find it, particularly if they've had a full year off, they're going to find it harder to get back into the workplace. And that's an argument you run. But you're running it now on the basis that, you know, they're out of the workplace, you know, that for them, their protection is extended for that additional 6 months that they would have in a redundancy situation coming back from maternity leave. So just very recently, in the last 2 weeks, we ran an argument along that basis, and for whatever reasons, the employer did cough up a lot more cash. So I think they were worried, given that potentially, although it's not legislation yet, with the view that it could be in April, that person would be impacted. Because they would still be in maternity, you know, they would be in maternity leave, and then we've got the legislation that would potentially protect them. So just giving that as a headline for people to think about.
Great. Thanks for sharing that, Susanna. I don't think there's no questions at the moment. Does anybody else have anything to say before we move on to Susanna's section? No, I think we're good. Okay, so just to quickly hand over to Susanna, who's going to speak about proposed changes to annual leave and TUPE.
Yeah, well, finally, I think we've got a bit of pragmatism and common sense prevailing from you know, our government and the Department for Business and Trade. So I'm going to be looking at, in particular, around about annual leave, holiday pay, some record keeping requirements, and then some proposed relatively minor change to TUPE. But they're interesting, and they're all to a certain extent helpful. Whilst we, again, just like Harriet has said, we don't have specific time frame of when this is going to be introduced, but we're looking at probably the back end of 2024. So what are we talking about? On the 10th of May of this year, the Department of Business and Trade issued a policy paper which they call Smarter Regulation to Grow the Economy. And this has been devised as a process of changing coming out of the EU. And so they've got an opportunity to look at a number of things, and that is what they're doing. So we've got a consultation document with a number of proposals, and I'm going to outline some of those proposals to you. And I just want to let you know that the consultation ends very soon, 7th of July. So if you feel very strongly about some of the points I'm going to talk about, you've got an opportunity to submit representations to the Department of Business and Trade in respect of these, and they are very much inviting people to put forward their recommendations and their thoughts. So I think there's an opportunity here for you still to be advocating. So the first thing that we're going to look at is the calculation of annual leave. The current position, as you know, is that we have the working time regulations, and under those workers are entitled to 5.6 weeks of paid annual leave each year. But that is split under the working time regulations between Regulation 13, which currently permits the 4 weeks for each year, so the 20 days for full-time employees. And we have also then Regulation 13A, which provides for that additional 1.6 weeks, which we cover off as the 8 days public holidays. That, in a way, is unhelpful, because what it does is that we have different ways of calculating pay in respect of those separate types of holiday. So the first very sensible and pragmatic proposal is that we will get rid of regulations 13 and 13A, and they will be replaced by one regulation which will entitle a single entitlement to 5.6 weeks paid annual leave. Now, that is, I think, a sensible proposition, but it also then has a bit of a knock-on effect, in particular around how you will pay for the 5.6 weeks. Now, in my experience, most employers are actually, again, being quite pragmatic purely for administration reasons, and they don't split out the holiday and work it out in different ways, but some employers do. So when we're looking at the holiday pay, as I said, at present, because we've got these two regulations that prescribe in relation to our 5.6 weeks holiday, the position is that the 1.6 weeks under regulation 13A, that pay is calculated based on basic pay and shift pay, while the 4 weeks under regulation 13 is based on normal remuneration. And you'll be aware that we've had this plethora of case law around this point as to what is included in normal remuneration. We've had a lot of case law around it, and it's been extended to cover things like overtime and commission are included. And so that is actually causing and has caused quite a lot of additional cost to employers, and it's also causing a lot of headaches along the way because it requires just more administration and management of it. Now, rather unhelpfully, so they want to look at this whole thing about holiday pay and what we're going to pay people and how we're going to pay people for the 5.6 weeks. But they unhelpfully have not put forward any formal proposal for what that is. In fact, that's where they're inviting people to put forward submissions on how they think pay should be calculated. And they recognise, obviously, that there is a significant additional cost to employers if we were to use the normal remuneration calculation. But also that is, if we were to reduce it to just the basic pay, then there would also be financial impact for workers. So it is, as I said, asking for employers as well as workers to put forward submissions in respect of holiday pay. And hopefully by the end of the year, of this year, we will have some kind of response from the government in relation to this with some further guidance on it. There is, however, some really good news around rolled up holiday pay. So you certainly for any of the employers who have been paying people for fixed periods of time that they're working, or where they're working unusual hours, they work under 0-hour or casual contracts. It's certainly up until, it's up until quite recently, in fact, until last year, a lot of employers were calculating and adding on holiday pay using the 12.07% pay calculation. And that was based on the 5.6 weeks of statutory annual leave divided by your 46.4 working weeks of the year. And you will recall that we had a definitive case decision on this that said you cannot continue to do that. We've actually had legislation that says you can't do that either. But it has been a very convenient way of people being able to try to calculate and pay for holiday when holiday's been taken, when time is being worked in an unusual way. And so the proposal under the consultation paper is that that employers will be able to use the 12.07% to calculate holiday pay. And that is, in my view, entirely sensible. And it will also, assist a lot in terms of the administration of payment in those circumstances. So that's very helpful. The only thing I would say, if this is brought in, that does not let you off the hook in terms of obviously your duty of care and your health and safety obligations, which is obviously the requirement to allow people to take their holiday. when they're working these irregular working patterns. The other thing that they are looking at is providing a clearer method for calculating holiday entitlements for workers in their first year of work. At the moment, it is unclear from Regulation 15A which of the Regulation 13 or the Regulation 13A holiday accrues first. And so it's recognised that requiring annual and it's also recognised that requiring annual leave entitlement to accrue monthly is not always practical, as a month is not a standardised length of time. So the proposal that is being put forward is to move towards a system based on pay periods, which I find slightly unusual because most pay periods are monthly. So I'm not sure that that is really quite what quite such a movement from what we have already got. If and when the 12.07% pay comes in, just to highlight to you, the key thing that an employer will be required to do is to inform its workers that that is what it's going to be doing in respect of their holiday pay, and it will need to be properly and clearly itemised in the pay slip. Then we're looking at carrying over holiday leave. So at present, current situation is that your 20 days annual leave must be taken in each leave year period. And there is discretion that the 8 days, so the 1.6 weeks, can be carried over to a following holiday year, subject to a written agreement between the employer and the worker. And if someone is on long-term sick at the moment, they are able to carry over 4 weeks, but this must be used up within the 18 months from the date that it's carried over. And there is a proposal to change that, and the change will be relating to people who are on long-term sick pay, that they will be entitled to the full statutory annual leave entitlement. So they'll be able to carry over the 5.6 weeks over into another year. And actually, they're proposing that we lose the 18-month restriction. So you wouldn't be able to force the employee to take that holiday within that 18 months. That perhaps is not quite so helpful. In terms of record keeping requirements, we're quite loose actually in the UK currently, whereas the ECJ and at present we would be in conflict with the ECJ ruling on the Deutsche Bank case, where they have said that actually in terms of record keeping on the hours that your employees are working, you should be keeping these objective, reliable and accessible system in place so that you're recording exactly what somebody is doing each day. Now, what we have at the moment under the Regulation 9 of the Working Time Regulations is that we just need to keep adequate records that show compliance with the 48-hour minimum working week. And what the proposal is that we scrap that completely. So the proposal under the consultation paper is that we don't keep any records of that. And whilst you might think, wow, well, that's brilliant, that's really helpful, thanks very much, one less thing to do, I do just want to alert you to the fact that we have the national minimum wage legislation, which is not being changed, and that does require records to be kept to ensure that you've got compliance with national minimum wage obligations. So you are obliged to keep sufficient records to establish that your workers receive the national minimum wage, if that is applicable in your business. So on the one hand, it's useful, but we're not completely off the hook of not having any records at all. So I don't know if there's a question about holiday, because I've just seen something pop up in the comments, but if there isn't, I'll move on to TUPE.
Susanna, there is a quick question about holiday. I should also add that just before the webinar, Jane suggested that we let everyone know when the dates of each piece of legislation is possibly going to come in. And so, Jane, just to let you know, we'll be doing that on a sort of a case-by-case basis. So each speaker is speaking about the dates, but in short, we don't know the precise dates for all of them.
No, so what we do know about the holiday is that the consultation closes on the 7th of July. We expect the response back by the end of 2023. And we don't think that any of these proposals, because they might not all come into place, but I would suspect that they're not highly controversial, to be honest with you. And so but that won't be till the back end of 2024.
Okay, and just to read the question now for the benefit of those that can't see it or who are watching the recording, the question is, can you clarify the rules around carryover of holiday in relation to somebody who's been on maternity leave who has accrued lots of holiday leave? Does anybody know the answer to that? Or I can jump in. Susanna, have you got it?
Oh, go for it.
No, by all means.
Well, so if somebody's accrued, that people are entitled to accrue holiday during maternity leave, and then to carry it over. What we tend to see is that there are often within a maternity leave policy, the employer may well then state when they want that holiday to be taken. So frequently you see that there is a request that the accrued holiday is added on to the end of the maternity leave. That's kind of a common thing that happens.
Yeah, perfect. That's great.
Harriet, have you come across anything else, anything different really that's more common?
No, not always added on to the end, but I suppose sometimes within a certain amount of time after they've come back, so within 3 months or so, just to make it manageable. There's often a lot being accrued.
Yeah, 3 months, and that's right. So and the short answer is that people can carry it forward as well.
Yeah.
Great. Okay, and we've got 13 minutes left. So Susanna,
so I'm going to go really TUPEs really quick.
Okay.
Again, it's a pragmatic proposal at the moment. You will be aware that if you are in a TUPE situation, there isn't a union recognition, then if you're an employer with more than 10 employees, you have to elect employee representatives to consult with and to inform and consult in relation to the TUPE consultation. And the proposal under the consultation paper is that if you are a business with less than 50 employees, then you will not have to do that. You will not have to elect employee representatives. You will be able to consult and inform directly with employees. And the other thing that's being proposed is that any business of any size where the transfer relates to fewer than 10 employees, you will also not need to appoint or elect employee representatives. You will be able to just directly consult. I think all of us were hoping that there would be a lot more that we might see coming out of a consultation proposal in respect of TUPE. What I can tell you is that under the consultation paper, and again, I'm inviting you, if this is a big issue for your business, to consider whether you want to make representations, is they are asking for people to put forward suggestions. And if we've got time after Dom does his bit, I've got some ideas that you might want to think about on that.
Great. So I just forgot to take a mute off. Yeah, we should have some time at the end, hopefully, Susanna. We've had a question in about the TUPE element of this. So, and the question from Caroline is, how do the changes relate to establishments? A company could have 100+ employees, but in one establishment maybe 49. What would happen here? I'm not sure.
No, it's about the size of the whole business, is my reading of it. It's not about an establishment. It's about the size of the company.
Perfect. Okay, thanks, Susanna. That is great. Okay, Nola, and did you have anything else to say about TUPE, Susanna?
No.
Okay, thanks for that. That's fantastic. And Dom, just moving on to you very quickly to discuss the proposed changes to the rules regarding third-party harassment. So over to you, Dom.
Thanks, Dean. So as mentioned, I'll be talking about the reintroduction of the liability of employers for harassment of its employees by third parties and the specific duty on employers to take all reasonable steps to prevent sexual harassment of their employees, as well as what employers need to know moving forward. So the Women and Equality Select Committee published a report in 2018 which highlighted the extent to which sexual harassment in the workplace remains persistent. The Women and Equality Select Committee's conclusions and recommendations were assessed by the government, and they prepared a publication which set out their response. This can be viewed on publications.parliament.uk, and I can put in the link to that in the chat box after my discussion. As a result of this, the government is supporting the Worker Protection Bill of 2022-23, which is an amendment of the Equality Act 2010. And the bill will introduce a duty on employers to take all reasonable steps to prevent sexual harassment of their employees. It will give employment tribunals the power to uplift sexual harassment compensation by up to 25% where an employer is found to have breached the new duty to prevent sexual harassment. It will reintroduce employers' liability for third-party harassment. Now, this will be where the third party harasses the employee in the course of their employment, and the employer failed to take all reasonable steps to prevent the third party from doing so. And it will provide that an employer will not be considered to have failed to take all reasonable steps to prevent harassment of an employee by another employee or by a third party solely because it does not seek to prevent the expression of opinion in conversations or speech in certain circumstances. So you can track the progress of the bill online, and it's currently at the committee stage in the House of Lords with unfortunately no exact date of when this bill will come into effect, but hopefully we receive further information on this later in the year. And I can put the link once again to that in the chat box after my talk. So employers will already be mindful of the fact that sexual harassment in the workplace is unlawful. However, they will now be legally required to put in place measures to seek to prevent harassment. So it's always been advisable before the government announced their support for the bill to have clear anti-discrimination policies in place. However, it may now be necessary to have a specific policy dealing with sexual harassment, which not only seeks to prevent sexual harassment in the workplace, but also creates effective reporting channels for employees. Such policies should be well publicised in the organisation. If employees are aware that their employer is taking active steps to prevent harassment, then this will potentially create a culture of intolerance of such behaviour and openness to address it. Employees may then, in turn, be more likely to report incidents in the future. So employers will also be well advised to ensure that anti-harassment training is provided to all staff and that it is reviewed on a regular basis. Failure to take all of these steps is likely to result in an employer being in breach of the new mandatory duty and therefore suffer increased liability should they find themselves involved in employment tribunal litigation. So if you are considering the effect that this bill may have on your business and would like to discuss the employment law implications of this, once again, please feel free to get in touch with the team. Thank you.
Okay, that's great. And Susanna, did you mention there's something else you wanted to cover in the last moment of the webinar? Oh, you just unmute, sorry.
Yeah, no, I was just going to say, if anybody was thinking that they'd like to write in on the consultation paper, then in particular about sort of other areas of TUPE that they might want to sort of have looked at, you know, there are a number of things that probably would be helpful, wouldn't there? So I just thought of, you know, identified a few. I mean, I think first of all, there's something along the lines of let's restrict TUPE to employees only and not workers. It'd be really useful to remove the special restrictions on changing terms after a TUPE transfer. It would also be really, I think, quite useful if we could remove the need for special ETO reasons for TUPE redundancies, so that we don't get into the situation where everybody's, you know, waiting for this sort of artificial transfer date before they then deal with the redundancies. I think it would also be useful to allow settlement agreements for TUPE claims. Ironically, you can settle a TUPE claim through an ACAS COT 3, so it seems slightly unusual that we can't use settlement agreements. I think it would be helpful if we could remove the need to elect representatives when there are no measures involved affecting the employees. So that happens quite frequently, but you still have to go through this election process where under the new rules there'll be more than 10 people affected. And I think that'd be useful again to have some clear position made in relation to post-termination restrictions after TUPE transfer. As you'll know, existing terms and conditions transfer, and those existing terms and conditions are with the, in particular in relation to post-termination restrictions, are with the old employer and not necessarily afforded the protection to the new employer with the transfer taking place. And unless your contract is specifically drafted to cover that point, it can cause some real issues. So those were just some things I thought that, you know, it'd be useful actually if we were really going to tackle TUPE legislation to look at some of those things.
Yeah, absolutely. And I'm just going to copy and paste the two links that Dom, for some reason, is not able to copy into the group chat here. So I'm just going to drop this in. I mean, if anybody does want them, of course, just drop us a line. You can email Dominic directly. So domonic.lyons, Lyons @joneschase.com if you need them. But they're on screen at the moment. And I don't think we have any further questions, so we're just going to finish a couple of minutes early. Just once again from us, thank you very much for attending. We do appreciate it. The information that we've covered today is accurate as of the 22nd of June 2023. If you have any questions, do drop us a line. We always like helping people. And of course, if there's anyone out there that you think would benefit from these webinars, Suzanne and Shona's fantastic podcast, or any of our other content, do drop us a line. One of the easiest ways to reach us is info@joneschase.com, and we'll react accordingly. So once again, actually something's come through in the Q&A. Just have a quick look at that. So thanks to all of the speakers. Will you be sending slides of the webinar? I'm afraid we don't have slides of the webinar. However, the webinar has been recorded, and the whole thing will appear on our website in the news and events page, and also on YouTube as well. We're currently not getting a load of views on YouTube compared to the musical artists that I do like watching and get millions. But we're working on it, and we are building a profile. So yeah, if you search for Jones Chase Employment Lawyers on YouTube, all of our webinars and also some other videos are there as well. Okay, so that's it from us. Thank you very much for attending, and we look forward. And we're doing these webinars quarterly now, so unless something particularly dynamite appears, so we will see you all again in this format in 3 months' time. So thanks very much for attending, and take care. Bye-bye.
Bye.